Okay. We are on.
Found the name, but I can't find the phone number.
I forget it.
Okay.
She said she was gonna come.
What?
She said she was. Yesterday was my birthday,
Very good.
so she said she wasn't gonna come. I think she was gonna bring a cake here. I don't know. Well, let's hope she comes. Everyone's invited to a piece of cake.
All right. Okay.
If
Now-
I could take some coffee, you can take some coffee.
You did through the Mishnah in the beginning of the Gemara yesterday, right?
Yes,
So that was on the bottom of right, Kaf
kafala from
Aleph Amud Beis,
the day,
Right.
right.
right? Okay, great. So that's where we're going to pick up. Right, so we had this whole Geschichte here, this whole business. And the end of the Gemara says, Reish Lakish Ama Patur. He said, Lo alima milta deshtala. Reish Lakish is not willing to accept this idea that the document would be binding unless it was given in front of witnesses. Okay? And that's why he says he holds that the unsigned document then is not valid. Okay? So what happens? It's not. That's what we're going to pick up next to the last line. Okay. Harvey was there in show. I thought he was going to go home and get on Zoom. Okay, so it's not. The Mishnah says, "Hanoseyet ha'isha upaska imo lazunet bita chamesh shanim." A woman marries a man, okay, and she has stipulated, right, that he must feed her daughter, in other words, his stepdaughter, for 5 years. Chayav lezoneh chamesh shanim. He's obligated to feed her for the 5 years. Okay, my love ki hai gavna. How is this similar to our case? Asks the Gemara. In other words, is there really a parallel to the document binding him according to the view of Rabbi Yochanan? So now we get to today's daf, which is Kaf Beis Amud Aleph, right?
Yes.
So the Gemara says, "Lo, b'shtari psikta ukat Rav Gidl." No, we're talking about a situation of a document of stipulation, which is considered a legal document, okay? And the issue is, we would almost call this similar to Tanayim, okay? But it's not exactly Tanayim, okay? So what happens? And this document, there is a question of witnesses or of any kinyan going on. Ukat Rav Gidl. And this we're going to see according to the view of Rav Gidl. Okay, why? The Amar Rav Gidl, Amar Rav. Rav Gidl says in the name of Rav. Okay. Right, the following. Right. Kama ata noten lebincha. The father of the groom says, how much to the father of the bride, says the father of the groom, how much are you willing to contribute for your son? Kach v'kach, he says that amount. V'kama ata noten lebitcha. And how much is the father of the groom to the father of the bride? How much are you willing to contribute on behalf of your daughter? And he says, kach v'kach, so much. Okay? What happens to amdu v'kidshu? Therefore, the two fathers stand up. They guarantee that this is a kedushin. In other words, there's a kinyan there. And as a result, okay, I think this is your lady coming right now. Okay, kanu. Okay. Yeah, I'm waving her on. All right. Okay. Hein hadvarim haniknin ba'amira. These then are things that are purchased, are acquired by means of a verbal statement. In other words, even if it happens,
Right over here.
okay, even if it happens here, just without a document. Okay, okay. Good morning, Tashma. Listen to the following writer. Okay, so we're trying to make comparisons now. Katav l'kohen she'ani chayav l'chamesh sla'im. If somebody writes a document, the promissory note to a kohen for a pidyon ben, that he owes him the 5 selah, right? Chayav l'tein lo chamesh salim. Salim, he is obligated to give him 5 sela, ubano eino padui, but the son has not been redeemed yet. Okay, so the Gemara says, Shani hatam, the Mishu Abad Lemida Oraita. Maybe that's not a valid comparison to make, because there the father of the child is obligated from the point of view of the Torah. Ihachi amai katav. If that's the reason, why did he even write such a promissory note to the Kohen? Right? Kadei levarei lo Kohen, in order to finalize and make arrangements with a particular Kohen. Ihachi, says the Gemara, if that's the case, bano amaye no padui. If that's the case, then regarding the son, why is he not considered to be redeemed? Kida Ula, as was stated by Ula, namely the following. The Amar Ula, as Ula says, Debar Torah Padui Kleshayitain, that according to the rule of the Torah, the redemption of the child doesn't occur until the money is actually handed over to the Kohen, right? Umay Tama, what's the reasoning, Amru? They said, Bano Eino Padui, that our Braita says that the child has not been redeemed. Gezerah Shema Yomru Podin B'shtarot, lest people take the attitude that there is a Gezerah, a decree, and as the rabbis made a decree that you couldn't just give the Kohen for the Pidyon Ben a shtar, a promissory note. You actually had to pay him the money at the Pidyon Ben. Okay? Amar Rava, says Rava K'tznai. Maybe this argument that we see here that was between Reish Lakish and Rabbi Yochanan is similar to a earlier Tannaitic argument, namely based on the following situation. Al-Rav, a guarantor, Hayotse Achar Hayatom, okay, who goes after the situation of the heir. Shtarot Gova Minichasim B'nei Chorim. Okay, all right, so what happens? You have the promissory notes, but he collects he can only collect on property where there's no lien on the property. Why is this the case? Maaseh ba lifnei Rabbi Yishmael, a situation occurred before Rabbi Yishmael. Va'amar gova minichasim b'nei chorim, and he said that one can collect from property that is not mortgaged, it's not sold. Amarlo ben Nanas, but Ben Nanas challenges Rabbi Yishmael and says as follows: Eino goveh lo minechasin b'nei chorin v'lo minechasin mishubadin. He cannot collect, okay, the guarantor either from, in other words, the creditor cannot collect either from the non-mortgage property or mortgage property, sold property. Amar lo lama, and he says to him, why is that the case? Amar lo, harei shehaya chonek et chavero b'shuk. Why? Because there was once an incident where the creditor, the one who was owed the money, grabbed hold of the debtor and started choking him in the marketplace, right? Umatzah chavero, and along came the friend of the debtor, okay, who was acting as the guarantor. And what had happened? Va'amar lo, and he says to the creditor, Hinach lo va'ani yaten lach. Leave him alone, and I'll pay what he owes you. Right? Patur, this guarantor is actually exempt, even though having verbally said that. So we're thinking, well, it's a verbal statement. Isn't that sufficient? Just like we saw the verbal statement in our case of the husband, of the man saying he's willing to pay for the stepdaughter's sustenance, right? Shelo al amunato halahu. Why? Because this was not based on any trust arrangement with the arev, with the guarantor. So the Gemara therefore says, if that's the case, Lema Rabbi Yochanan Da'amar Rabbi Yishmael. Maybe we'll say then that Rabbi Yochanan said similar to the view of Rabbi Yishmael. Reish Lakish Da'amar Ben Nanas, and that Reish Lakish holds like Ben Nanas. That would then tell us that the machloket of Rabbi Yochanan and Reish Lakish is similar to this earlier Tannaitic argument between Rabbi Yishmael and Ben Nanas. So the Gemara says, hold on a second. Ali the Ben Nanas, according to the view of Ben Nanas, Hui Amalo Pligi. No, everybody is not, there is no argument here, except in the following situation. As we go to the next Amr, Ki Pligi, where do they argue? Ali the Rabbi Yishmael. They argue about the view of Rabbi Yishmael. Rabbi Yochanan to Rabbi Yishmael, that you're suggesting that Rabbi Yochanan follows the view of Rabbi Yishmael, the Reish Lakish. But what about Reish Lakish? Ad kan lo kamar Rabbi Yishmael hat. It would therefore imply that Rabbi Reish Lakish does not hold like Rabbi Yishmael in that situation. Instead, he must hold like Ben Nanas. However, the Gemara tells us, Ella, rather, the Shayach le Lishia Buddha. Rather, that's only because we're dealing with properties that have a lien on them, mortgaged or sold, de oraita. And that's based on the fact that that is the law of the Torah. Okay? An example of the Pidyon Ben that we see there. Aval hacha. But here, in this case, lo shayach she'ibuda de'oraita. Here we don't see any obligation on the part of the Torah. Amar Rav Gidl. So now Rav Gidl is saying that follows Amar Rav in the name of Rav, a somewhat new statement. Kama atad. We're going back, Gufa. We examine that statement. Okay? When he said that the father of the bride says to the father of the groom, Atanoten lebincha kach v'kach, kama atanoten lebincha kach v'kach. How much do you give on behalf of your son? And he says, so a certain amount. V'kama atanoten lebivcha kach v'kach. And how much do you give on behalf of your daughter? And he says, so and so amount. Amdu v'kitshu. They stood and they made the Kiddushin. They made in other words, they guaranteed this wedding, right? Kanu. Therefore, this is the kinya. Hein ha-dvarim ha-niknin ba'amira. Thus, this is an example of words that are shared, and it establishes the firm bond like a kinyan, but it's based on a verbal agreement. Okay, appears to be no document there. Okay, so what happens? Amar Rava, says Rava as follows. Mistabra milta de Rav. Okay, it seems logical to follow the view of Rav. The bito na'ara. When in this situation, the daughter is only a na'ara. She's only between 12 and 12 and a half. Why? The kamate hana'a lidei. Because in that situation, when the father marries her off, the father receives a financial benefit. Aval bogeret. But if we're talking about a girl who's more mature, 12 and a half or more, right? What happens? Delo mate hana'a lidei. That there is no financial benefit then to her husband because she gets the money herself. No. That's not, it wouldn't work then. So the Gemara says, Vaha Elohim, by God's name, in other words, an oath. Amar Rav afilu bogeret. Rav says that verbal agreement, okay, without a document, without witnesses, should still nevertheless be valid, even for a girl above 12 and a half. Why? De'ilo temahachi. Because if you don't say so, avi habein mai hana'a atalidei. As far as the father of the groom, what benefit does he have? Right? Ele bahahi hana'a tekemichatne ahadade. But rather we do say he receives some benefit, namely that he sees this couple married one to another. So the Gemara then says, Gamre umakne lahadade. Okay, so therefore we say we finish and we transfer the rights of payment one to each other. And so therefore that is a valid situation that each father agrees, and that's a kinyan, considered a kinyan, even though there's no document and no witnesses. Okay, now the Gemara picks up and says, wait a second. Okay, we're not happy with this conclusion. Amarle Ravina the Rav Ashi, and Ravina says to Rav Ashi, the Varim halalu, asking the question, these things, these words, this verbal agreement between them, nitnu lekatev, or lo nitnu lekatev, were they given to be written? In other words, do we then still need a document, or don't we need a document? Amarle. So Ravina answers Rav Ashi, lo nitnu lekatev. They were not given to be written. Now, the Gemara is going to have a problem with this answer by Ravina. Eitive, Rav Ashi challenges him. Didn't our Mishnah say specifically, Hapikhin hayu kotvin al manat she'azun et bitach chamesh shanim kol zman she'at imi? The smart men, okay, under that situation, write down in a document that I agree to the stipulation of providing food for the stepdaughter for the 5 years, as long as you are with me. In other words, as long as you continue to be married to me. Okay, so the Gemara challenges it. It says, my kotvim, what do you mean when we say in our Mishnah that it implies that something is written? Omrim, we see in the example that they actually spoke. They didn't write anything. V'kari le la'amira k'tiva. And do we ever really say that when there's a spoken agreement, it's the equivalent of writing? And says Rav Ashi. Okay, so Ravina responds, yes. V'hatnan. Aren't we taught elsewhere in another Mishnah? Hakotev le'ishto dinu dvarim ein li b'nechasai. One who writes to his wife, okay, that I have no judgment, no financial arrangement. In other words, no agreement to obtain part of your property, your earnings, things like that. Vatani Rabbi Chia, ha'omer li'ishto. And Rabbi Chia taught that this meant that he was saying it to the wife. Tashma. But listen to the following, the Braita, says the Gemara. Ein kodvin shtare erusin v'nisuin elamidat shnehem. We do not write documents of betrothal or marriage unless it's with the agreement, the understanding of both of them, namely the groom and the bride. Ha, midat shnehem kodvin. Here then, we learn from the Braita that from the agreement of both bride and groom, we can write such a document. My love, what is it not therefore the following? Shtari psikata. Aren't we then talking about a document of stipulation? In other words, that it stipulates the certain things? No, says the Gemara. Shtare irusin mamash. No, we're talking about a betrothal document, what we would really call today Tanayan. Okay?
Unless they write it down, and how could they get pick and the agreement they have? As long as she's his wife, he'll agree to support her.
We'll see. Kidarav Papa Rav Shravya. And this follows the view of Rav Papa and Rav Shravya, the Itmar, who among whom, for whom it was said, Kadvu lishma v'shelo mida'ata. If they wrote it, okay, for his benefit, but without, okay, in other words, they wrote it for her, but without her cognizance. All right? Rabba v'Ravina, Amrei mikudeshet. Rabba and Ravina both would say she is betrothed. Rav Papa v'Rav Shravya Amre Eina Mikudeshet. The two of them would say she is not betrothed. Tashma. So we now get to a new Braita, right? That tells us the following. Metu. What happens in a situation where the husband or two husbands have died? Namely, not only the first husband with whom she had that child, okay, but now the second husband who had agreed to the stipulation of giving sustenance for the 5 years for the stepdaughter. Okay? Benotehen nizonot minichsin b'nei chorim. Any daughters that survive that second marriage, I'm going to say, if they need sustenance, that sustenance may come from property that has not been sold or liened or mortgaged. Vehi, but I'm going to say the stepdaughter, nizonet minichasim mishubadim, but she is to be given sustenance from property that has a lien or mortgaged or been sold. Why? Why? Because she is like somebody who is a creditor. Okay? Hacha, in this case, what are we dealing with? B'shekanu miyado. Namely, that there was a kinyan here, that was an act of acquisition from the husband on behalf of the stepdaughter. Ihachi, if that's
prenup. What you're talking about is a prenup.
exactly a prenuptial arrangement. Right? Ihachi, if that's the case, benot nami, then his own daughters, that also should be the case. B'shekanu lazo, v'lo kanu lazo. Maybe it's possible that there was a kinyan with the stepdaughter and no kinyan with his own daughters. Umay paska. And what was the stipulation then? Ihi dahavi b'sha'at kinyan. That she, the stepdaughter, was alive at the time of that kinyan, at the time of that acquisition. Mahani la kinyan. And therefore, the kinyan is viable for her. Benot, but any daughters that came as a result of that, for him, it could have been the first marriage. For her, it was her second marriage with whom she already had a daughter, right? So those daughters that came from his for him, that relationship. But no, those girls maybe were not in existence at the time of that acquisition, of that time of that kinyan. Lo mahani, it doesn't apply. Laho kinyan, there's no application of the kinyan for them. So the Gemara challenges that explanation. Mi lo askinan, the have b'sha'at kinyan. Don't we say that even his own daughters were alive at the time of that kinyan? Okay, the time when he made that agreement for sustenance for the stepdaughter. Behechi dami. How is that possible? How can we understand this? Kigon de garsha va'ahadra. It's possible that he divorced her and then he took her back. In other words, for her, okay, she had been married before, had his daughter. Then for whatever reason, either that husband divorced her or he died. She now marries the second man, okay? What happens is he agrees to a stipulation, okay, for this issue, for this sustenance. But then, furthermore, he divorced her, but then after having daughters with her, and then, however, he takes her back. Okay?
They said the first husband takes her back.
No, the second husband is taking her back. Okay? So what happens? Okay? So that's the suggestion. Ella rather, Ihi, but regarding her, namely the stepdaughter, Delita Batanai Beitin. Maybe we're going to say here in this case, there is no stipulation of the court to guarantee her support. Okay, mahani la kinyan. But we do therefore have this example of the kinyan, okay, of the document of the stipulation that he made verbally. Okay, Benot, but his own daughters, the itnahobatanai beitin, who do have a stipulation of the court for support because they're his daughters, and according to the halacha, right, of the Beis Din, they are to get that support from their from the estate of their deceased of their father. Okay, what happens? All right, the itnu b'tnai beitin lo mahani lehen kinyan. Therefore, that earlier document of that earlier statement of stipulation, okay, does not apply, and there's no kinyan there. All right,
And there's no Kenyan
for the natural daughters as
The
opposed
natural.
to the stepdaughter.
in other words, the
That's-
stepdaughters are going to get preference then.
That would appear. So that's what the Gemara is challenging. Exactly, Zach. Migrai Gari. Are you saying then that the rights of the daughters are weakened because they don't have the stipulation of the court, and the status of the stepdaughter is better than them? Ella rather, benotav hainu tama. No, we could say giving a different explanation. But regards to his daughters, this is the explanation. Kevan de idnahu b'tnai beitin, since they do benefit from the stipulation of the court, right? Emar, I might say, srare it pasinhu, that he gave them bundles of coins in advance, okay? And therefore they have money. And that's why we can say that they don't get benefit from the earlier stipulation for the stepdaughter, but only the stepdaughter does. So let's finish up a bit. Lo amra harishon. When we said that there are the two husbands, the two of them can't say, well, I'll feed her when she's by me, etc. Amar Rav Chisda, zot omeret bat etzel ima. This tells us that the daughter stays with her mother. Mimai, the bigadola askinan. How do you know that we're talking about a girl that is more than 12 and a half? In other words, grown-up. Dilma biktana askinan. Maybe we're talking about that the stepdaughter is a minor. She's 12 or under. Okay? Umishum ma'aseh shahaya. And the reason we say that the daughter stays with the mother is because of an incident that actually happened. And right, Tanya, as we learn in the Braita, Mi shamet v'hiniach bein katan le'imo. The husband died, and he left a small son, a minor age son, with the mother. Yershei ha'av omrim, the heirs, in other words, the older sons from a different mother say, okay, what do they say? Yehe gadal etzleinu. Okay, let him grow up with us. V'imo omeret yehe bani gadal etzli. Let my son grow up with me. So what happens? Manichim oto etzel imo. We should leave him along by his mother. Ve'ein manichin oto etzel ra'ui liyorsho. And we do not put him by those who are going to be entitled to inherit. Why? Maaseh haya. There was once an incident, v'shechatuhu erev haPesach, or erev harishon, and they killed the kid. Okay, so they would get more of the inheritance. Right? Okay, so that's to finish up. Im kain litnei lemakom shehi. If that's the case, then we should say in our Mishnah that they provide the food to the place where she is, where the stepdaughter is, not where the place where the mother is. And we'll finish, Mai lemakom she'ima. Why then did our Mishnah say in the place where the mother lives? Shemat mina bat eitzel ha'ein. That we learn therefore that the daughter stays with the mother, v'lo shana gedola, v'lo shana ketana. And there's no difference whether she's of a majority or minority age. And we'll stop right there.
It doesn't say anything about its son.
No, it doesn't say
So if
anything.
you have a son, then okay with the son.
The sons naturally get, they get their portion.